On the bill as amended, again, we've already touched on it. I'd turn it over to Mr. Moncla at this point.
Yeah, thanks, Chairman and members. When our new governor was elected, he appointed several transitional councils to help prioritize state issues needing to be addressed within each council's purview. For the Energy, Chemical, and Maritime Transition Council, known as ECM, 3 items surfaced in almost every meeting and were the main recommendations to the governor: fixing legacy lawsuits, improving the time frame on drilling permits, and getting competitive with other states on severance taxes. Being this isn't a fiscal session, we couldn't address severance, but the governor made 2 great appointments in Tyler Gray and Ben Bienvenu to address the permitting issues. But the remaining and most important issue brought to the Governor's Council was to make Louisiana attractive to investment again by fixing legacy lawsuit litigation, and that's why we're here today. Since the ECM made their recommendations, I've heard the governor speak at 3 public venues where he made declarations that Louisiana is back open for business. Well, fixing legacy lawsuits is ground zero in that regard, and if we really want to be back to open for business, we have to fix this. The current law, Act 312, was established in 2006. Since that time, there have been an onslaught of legacy lawsuits. There were over 800 going at one time. Today, there remains 586 on Louisiana's Sonorous website. These lawsuits have pushed industry out of our state, and we hear all the time that operators don't want to return here in this legal environment. And even private equity firms have refused to consider investing in companies focused on Louisiana projects. Over the last few months, LOGA has worked on legislation to amend Act 312, all the while with the goal in mind to compromise with landowners. I am proud to say that both landowner associations in Louisiana, LLA and NORMA, have agreed to the changes proposed in Act 312. They too are ready to go back to work on their land. This legislation doesn't relinquish oil and gas operators from cleaning up environmental damage. If operators damage properties, they should clean them up. This bill merely allows the state departments to use regulatory standards, allows the district court to adopt the most feasible plan, provides more clarity and certainty to both the responsible party and the landowner, and it limits recovery of additional damages, as in other states. With both groups that are a party to this litigation, oil and gas and landowners, together in agreement to the amendments to Act 312, LOGA asks for your favorable passing. Thank you.